All right, we are live streaming at this point.
It's better than sitting and watch it.
Welcome everybody. It's 9:30 and I want to just make sure that we have a quorum. Let me look around.
Yes.
Rachel, it appears we do have a quorum. I just want to double check looking at the list. Representative Geiger and Representative Hassenfuss, can you make sure to turn your cameras on? We do need to see everybody in order to confirm a quorum. Representative, there you go. Thank you very much. Thank you.
Sorry about that. You were right. I was trying to entertain children and get them set up. So
we're good now. We're good.
Grandmother's here now, and we're all set to go.
Great. So, good morning, everyone, and welcome to the Joint Standing Committee on the Innovation Development, Economic Advancement, and Business Committee. We are convening today electronically for the purpose of public hearing and public comment on legislation. We have 3 bills before us today, LD 11, LD 18, and LD 110, and we're going to take them in that order. In a moment, we'll have the opportunity to introduce ourselves to the public. I want to remind everybody that we are live streaming, and anyone that will be joining us for public comment will be live streaming and on YouTube, and also will be in the record. So please remember to turn off your mics and turn off your cameras if you don't wish to have that shared until you're ready to have that shared. A reminder on the Zoom identifier. I'm glad I have this list of prompts because it always prompts me to change my identifier to help people know how to reference. It helps us, all of us, or the public to be people coming before us know how to refer to us. So if you could put your representative or senator status on your title and make sure it's your name and not iPad number 6, that would be wonderful. Let's see, other notes we need to do, and I'm going to ask Representative Roberts. I'm just checking on. I actually don't see Representative Roberts yet, so
I had a difficult time finding the link today. The one that I had in my calendar did not work, and then luckily there was one sent out this morning that I just saw. So she may be having trouble finding the right link.
She's having issues.
Yeah, she's having issues. So we'll expect her to be joining us momentarily. And so, but what I was going to say, and I would also ask Jody or Ms. Breton, Mr. Senf, and Mr. Olson, if I forget any of the steps, please jump in and remind me of them. So let's see here. At this point, what I'd like to do is to go about and do introductions. So can we start off with introductions? I think most folks know the order, but if we could start out with Representative Geiger.
Good morning. I'm Representative Valley Geiger, District 93, Rockland and Owl's Head.
Representative John Andrews, District 73 in Western Maine, Buckfield and Paris.
Morning, everybody. Thank you, Mr. Chair. I'm Sarah Pebworth. I represent House District 133 in the Blue Hill Peninsula.
Good morning, everyone. My name is Amanda Collmore, and I represent District 106, Clinton, Detroit, and Pittsfield.
Good morning. My name is Louis Lucchini. I represent most of Hancock County in the Senate.
Representative Ducharme.
I'm Representative Jack Ducharme. I represent District 111, which is Madison, Norwalk, and Solon.
Representative Austin. Representative Austin, are you there? Representative Austin might be frozen. Representative Hassenfuss.
Representative Tavis Hassenfuss. I represent Winthrop, Reedfield, and North Monmouth, House District 81.
Representative Kyle Bailey, House District 27, which includes half of Gorham and part of North Scarborough.
Good morning, everyone. I'm Sue Bernard. I represent Caribou, Westmoreland, and New Sweden.
Representative Roberts, have you been able to join us? Not yet. Representative Austin, are you able to join us yet? No. I would expect them to be joining us back or coming back shortly. I'm Senator Curry. I represent Senate District 11, which includes the rural, coastal, and island communities of Waldo County. So welcome, everybody. And I hope we'll have folks joining us shortly and working out the bugs of their connections. So, and with that, I just want to ask for patience and acknowledge that this is a new system for all of us. We have a couple weeks of experience with coming in and out of Zoom in this format for this body. But this today especially will be a new day for using the public hearing method. And so there might be some pauses, some waits as we figure this out and make sure it's working for everyone. If there is an issue, I want to remind folks to not to do substantive conversations in the chat, because the chat is not being shared out there it doesn't go out in terms of the live stream. And so it's all substantive conversations need to happen verbally. But if there is an issue of a connection or a challenge that you're having in order to participate, you can put that in the chat, or you can reach out directly to our clerk or our analyst. And at this point, I realize I haven't introduced them. So also on this call in this meeting is Ms. Breton, who is our clerk, Ms. Senf, and Ms. Olson, who are both our OPLA, Office of Policy. I always call it OPLA, Policy and Legislative Analyst. Is that correct? All right, great. Who are our analyst. And then we will have a public hearing. Today, we also will have an interpreter, at least here, a sign language interpreter, at least for LD 18. Sign language interpreters can be requested at the off the legislature.maine.gov website for any bill, and typically, as practice, any bill that relates to ASL, which we will have a bill today on, we will schedule that in advance, but they can be requested at any point for any bill, and that's going through the website on at legislature.maine.gov. So let's see if I missed anything. We will continue to be using the raise hand feature for calling on folks. If you're trying that and it's just not working, please wave your hand around and I will work around it. So, and great. Representative Austin, I was hoping you might be able to say have the audio working. Representative Austin.
Thank you. Am I on?
You are.
Can you hear me? Oh, great. Okay. I had you, and then all of a sudden you guys all just blew away on the breeze. So good morning. I'm Representative Sue Austin. I hail from my hometown of Gray. I represent 3/4 of that, along with portions of Raymond, Casco, and all of Fry Island. And good morning, everybody, and glad to be here.
Welcome. Ms. Breton, I want to check in with you. Are folks ready to give testimony? Are they on the call and ready to do so?
I believe they're in the waiting room. I believe you're starting with Senator Pouliot's bill.
We are. We will be starting with Senator Pouliot's bill. There will be the mechanism for, yes, great. The mechanism for bringing people on. Ms. Brent will be bringing them on from an attendee into a panelist position in order to give testimony. So at this point, I would like to recognize Senator Pouliot.
Hey, good morning, Senator Curry and members of the Joint Standing Committee on Innovation, Development, Economic and Advancement and Business. I'm State Senator Matt Pouliot, and I'm proud to represent the districts of the residents of Senate District 15, Augusta, China, Oakland, Sydney, and Vassalboro. This is my first time presenting testimony in a Zoom call, so we'll see how this goes. I am actually presenting to you today, LD 11, on behalf of the State Board of Licensure for Professional Engineers. This is an act to clarify the laws regarding reciprocity for licensure of professional engineers. And normally in a committee meeting for public hearing, I'd be able to look around to verify that there will be others coming after me to give you more information on this bill, but I can't do that. So I'm going on faith here that others will be able to fill in more of the details for you, but I'll give you a little bit of an overview here, and would be happy to answer any questions when I'm done, but would encourage you to maybe save those for others who will be testifying, I hope, after I'm done here, as I've put this in on their request. So LD 11 is intended to correct the unintended consequences of prior legislation to remove barriers to professional engineering licensure for licensed professional engineers coming to Maine. Legislation was enacted in 2005 to increase licensure mobility for Maine professional engineers by raising requirements to the national model for all new licensees. Professional engineers who obtained their licenses under licensing pathways eliminated in 2005 are permitted to continue to practice if they keep their license active. Well-intended legislation enacted in 2013 was designed to establish equivalent license standards for professional engineers coming into Maine. This created the unintended consequence that qualified professional engineers who have practiced for years in other states are denied licensure in Maine because their alternate pathways were not grandfathered into the statute. So LD 11 would simply grant the board the flexibility to license qualified professional engineers who've been licensed in other states for at least 8 years with no discipline against their license. That's it, and I'd be happy to answer any questions.
Representative Austin. Representative Austin, do you have a question? Do you have a question?
I can make one because I have got some.
That's quite all right. I think your hand is left up from before.
Okay.
Representative Andrews.
Thank you, Mr. Chair. I didn't comment on a question. I just think anytime you have license reciprocity to get professionals into Maine, it's a good thing. So I'll be supporting this bill.
Great. Maybe you guys can move right into work session.
Representative Collmore.
I would like to second what Representative Andrews says. I think that it's important that we have much better reciprocity rules and regulations to allow more professionals to do business in Maine.
Representative Austin?
Yes. Senator Pouliot, I don't recall, has this been attempted since the era was, or the constriction of allowing the out-of-state folks to come in? Has this been tried in recent sessions? Or is this the first attempt?
It's my understanding this is the first time that this has been raised, and it's really coming from the Board of Licensure wanting to make it easier for folks to come to the state and continue to practice their profession.
So do they feel that, obviously they felt comfortable with the 8, is that a bit restrictive? 8 years?
I mean,
in comparison?
I think that it really brings with it the basic understanding that there would be some life experience in the field, and that in a period of 8 years, if one were to not be practicing to standard, things, hopefully would have caught up to them by that point. I think that if we were to shorten it to say, less than 5 years, we could end up getting folks who maybe just don't have enough life experience in the field to ensure that they don't need to go through the educational process here in Maine that, you know, the licensing requires. But I think that those, I hope, who will be here to testify after me, this is pretty bizarre. You know, 9 years in legislative service now. It's the first time I haven't been able to look around to ensure that somebody will actually be able to come after me.
It's
But
not very comforting, is it?
Senator Pouliot, let me just answer that question for you. Ms. Breton, is David Jackson with DPFR in the waiting room?
Yes, he is.
Okay, super. So David will be able to get into a little bit more details on that.
Thank you.
Representative Hassenfuss?
Yeah, do you know, are there any nuances to engineers practicing in the state of Maine that would be different from practice in other states?
Possibly. I mean, I think that there are national standards that are required, which was in part of the basis of this legislation when it was originally enacted, that I think would ensure that those standards are being met here in Maine. I think that, you know, Maine always has a unique way of doing business sometimes, but I think overall we can be assured that with 8 years of practice in other states in a licensed profession, that folks who come here and wish to practice, you know, will be able to meet the standards that we have in our state.
Seeing no other questions, and maybe people are waiting for Mr. Jackson from DPFR, we will end that there. Thank you very much, Senator Pouliot.
Thank you, Senator Curry and members of the committee. It's been interesting, and thanks for helping me get my feet under myself for testifying on bills this session via Zoom.
Ms. Breton, can you invite in, actually, if you can invite in, is also Ms. Triskill in the waiting room as well? There we go.
Yes, she is.
Okay, great. So we have next up is Mr. David Jackson from Department of Professional and Financial Regulation, and then afterward will be Ms. Triskill and to give testimony. So Mr. Jackson.
Good morning, Senator Curry, and I don't see, oh, there she is, Representative Roberts and members of the Joint Standing Committee on Innovation, Development, Economic Advancement, and Business. My name is David Jackson. I am the Executive Director of the State Board of Licensure for Professional Engineers. I am not an engineer, I am an attorney. I did not have the opportunity to introduce myself the other day when some folks from PFR came. If I might take a moment, Senator Curry, to introduce myself.
That would be fine. I'd also wonder if you might be able to turn your camera on? Or is it not in a situation where you can do that?
That, I believe, is Ms. Breton who...
Oh, let's get that solved.
I was wondering why I couldn't see myself on the screen.
Let's try to get that solved here.
I don't seem to have the ability to turn on Mr. Jackson's camera. I have it put on his microphone.
Mm-hmm. And
let's see if I can't find it.
I'm looking as well.
And I don't have a camera icon either.
You don't have a camera icon
on screen.
I voted you to panelists. So.
An odd.
Thank you for your patience. Let's spend a moment to figure this out. Ms. Breton, can you make sure to promote me to host and as well to Representative Roberts? I think that's why I'm not seeing everybody. Thank you.
Do you want me to try and leave and come back in? The equivalent of unplugging and plugging in.
Let's give this a moment, see if we can solve it on our own here. Representative Roberts, are you able to see anything different in the participant list?
And Mr. Chair,
Yeah, I'm looking into it right now on my other monitor to see what the issue may be.
Senator Lucchini?
one thing that's worked with us is we can make multiple co-hosts. So if both chairs can be made co-hosts, then you can, and as well as Ms. Breton, said she may not be listed as one now, and then you can do increased functions.
Right.
Yeah, Senator, you're the host now, so you'd have to make her. You'd have to give that back to her.
That's been shifted to me now. Okay. All right. I think we're both hosts.
There I am.
All right, we've got a great, we got to step forward, and I see that we're host and co-host. I think we're in place now. Excellent. So, Mr. Jackson, please continue with your introduction and your testimony.
Thank you very much. And I would like to really thank Senator Pouliot for stepping up and introducing our bill in the void, as it were, without knowing what was coming after. I appreciate that. And I appreciate seeing Representative Austin again. Are you the only carryover from the prior committee? And then I don't see Senator Searway, who I know from my time at the district attorney's office when he was with the sheriff's department. But it's not always nice to see friendly faces. I appreciate the opportunity to speak today. Just by way of introduction, I am an attorney, not an engineer. And I came to the law later in life after a career in construction and sales. I went to law school in my 40s. And moved to Maine immediately after sitting for the Maine bar. So then I had to sit for the Mass bar. So then I had to sit for the Maine bar as well. My wife grew up in the Waterville area, so we came up here. And as I was waiting to pass the Maine bar, I temped in the office of the Board of Licensure for Professional Engineers. Once I passed the bar, I sat as the public member of the board for a couple of years before I went to work for the office of the district attorney here in Kennebec and Somerset counties, and could no longer sit. And then a few years later, they called and asked if I would take over the position as executive director. And I've been here for 10 years as the executive director. Prior to my being there, and as I came on board as the executive director, legislation was in place, as Senator Pouliot talked about in 2013, to create an equivalency to what had happened in 2005. Many, the model standard nationally is 4 years of an engineering degree. You pass a first national exam called the Fundamentals of Engineering Examination, or the FE exam. Then you work for 4 years, that's the standard, and then you pass the second national examination, the PE exam, or which is the Principles and Practice of Engineering. And then you're licensed. You also have to provide references and verification of your work experience. So that model standard in Maine has a couple of variations, and it used to have more variations. There used to be experience-based exemptions for examination, and in Maine still, if you have a technology degree, we consider that equivalent to a straight engineering degree. And so engineering technology and engineering, ABET accredited or equivalent, are considered equal. What's called a related science or allied science degree, something like chemistry, biology, math, physics, those individuals can also be licensed as professional engineers, but they need 8 years of engineering work experience, which is where that number 8 comes from, to make sure that people are qualified. And in Maine, that's the alternative pathway, that somebody who has either an engineering or engineering technology degree that is not equivalent to the ABET accredited standard or a related science degree can become licensed with additional experience. The prior experience pathways, if you had 12 years of experience, you could waive the early exam. And if somebody had 15 years of experience, they could waive both exams and be given an oral examination. That's all gone now. And that was typically used by people coming down from Canada who didn't want to sit for the written national exams. And we understand that. However, the complication for the board there was that with 7 board members, 6 of whom are licensed engineers, they couldn't cover all of the 28 different disciplines of engineering with a sufficient level of competence to give an oral examination. And so you would either have to pay an engineer to come in and do that on your behalf, or find some other way to determine that these people were actually qualified. And we license to a standard of minimum competence. We don't license to, some, high, hugely high elevated standard. We license to a standard of minimum competence. As the board considered in 2005, raising the standard for all engineers who were becoming originally licensed in Maine, they moved that standard up to the national standards so that engineers who are licensed in Maine would be accepted in any other state. And that is a really positive step in terms of licensure mobility. Anyone who was practicing under a prior standard, for example, somebody who had an associate's degree instead of a 4-year degree, or somebody who had skipped the fundamentals of engineering exam, which is offered usually senior year of college or quickly after you graduate, because it's a fairly thin but very broad area of knowledge that you're tested on for that fundamentals, and then you tend to dive deep in one area for your second level exam. There are, for example, there are 7 FE discipline categories. There are 28 different PE exam categories. And so once you get past that initial sort of thin layer, people tend to dive deep, and they need specific experience and specific knowledge in the area where they're going to eventually be tested and become professionally licensed. Roughly 20% of all engineers become professional engineers, which means that they're entitled to direct the work and to submit documentation to public agencies on behalf of their clients or the entity they're working for. And the purpose of that is, of course, to assure the safety of the public. However, there's an additional mandate that the PE board has that other professional boards don't have. Our statute specifically says the health, safety, and property of the public. So engineers also protect the public property in addition to the public welfare. And the shift in 2005, anyone who maintained their license got to continue to practice professional engineering no matter how they were initially licensed. Several years ago now, we had an issue where an individual who had an associate's degree let his license lapse. He was focused on his business working in New Hampshire, and he didn't renew his license in Maine. At that point, our statute had a 90-day termination. If you didn't become relicensed, you didn't renew your licensure within 90 days, you had to meet all current standards. That's a fairly typical standard in most of the licensing statutes in the state of Maine. However, this individual came to the legislature and said, I don't think that's fair. We agreed with him. We didn't think it was fair. We thought he should be able to recapture his license. And so we were able to together craft a renewal standard that allowed people up to 3 years before they would have to meet the current standard. So if somebody's license can lapse now for up to 3 years before they have to be relicensed under the current standard. However, when the statute changed in 2013, for those coming into the state, we call that licensure by comity or reciprocity. Those folks, provision was not made for people who would have been qualified under our statute or their own statute at the point that they were licensed. And so there were people who did not take the FE exam when they were licensed, 15, 20, or even 30 years ago, who had to be denied licensure. The board has created a workaround that we've been doing for the past roughly year and a half, but that requires a hearing on every single one of those applications. So we've had roughly a dozen hearings in the past year to where the board finds specifically that a person is qualified in spite of, for example, not having that FE exam in their early qualifications. Frankly, it's a ridiculous use of resources. And so the board is coming to the legislature to request that we be able to codify this change so that the board can grant licensure once they've reviewed a person's qualifications and it's evident that they are qualified to practice engineering. And if, for example, they did not take the FE exam, umpteen years ago when they graduated from college, or they perhaps had an associate's degree instead of a 4-year degree when they started practicing many years ago. And initially, the board considered 10 years, but in consultation with stakeholders, including corporations who employ engineers throughout the state, that was revised downward to 8 years. And everybody felt comfortable that 8 years of practical experience in the field of engineering would supply any additional knowledge that's necessary to meet the minimum standard of competence for licensure.
Mr. Jackson, I'm going to ask you, typically we try to stay around 3 minutes and we're going a little bit long. So I'm going to ask you to wrap up, and we might get to more of this in question.
That's all I have to say.
Okay. Okay. Well, thank you very much. What questions do we have for Mr. Jackson? Representative Collmore.
Thank you, Mr. Chair. Thank you very much, Mr. Jackson, for your presentation. I have a question on the 8 years thing. Is it 8 years total as a practicing once they've exited college and they're a professional, or does it have to be 8 years as a licensed PE?
In what we're proposing is 8 years as a licensed PE.
So I guess my question would be, is that too much given that they already have to have 4 years of experience before they can even test for after having their education? And of course, this is excluding people who didn't have to go through those FE license tests and stuff like that. I mean, if somebody's been practicing in Massachusetts for 8 years and only has had their PE for 5, I don't know that they're any less qualified or any more qualified in 3 more years than they would be at the 5 year of a practicing PE, with another 4 years before that.
That's an excellent question, and that was a consideration as we looked around the country. That we found Idaho, and that's where we looked to. Idaho has a statute that is very similar to this, where they permit anyone who's been practicing for 8 years to become licensed. And that's based on Washington State, which is next door to them, has no education requirement. So somebody has, but they have to be licensed and practicing for 8 years prior to being licensed in Idaho. And so that we looked at that as an equivalent and borrowed the standard from that.
Okay, thank you.
Representative Hassenfuss.
Yes, thank you. I'm going to ask you the same question that I asked Senator Pouliot. In being an attorney and having taken the bar, you'll kind of understand the gist of this question. But is there any main specific areas of expertise that one would need to know to practice here, or is it basically the same across the entire country?
It's basically the same, and I can say that I've worked on national committees. All of the state licensure boards are together, make up the National Council of Examiners for Engineering and Surveying. All of the state engineering and surveying boards nationwide come together, and there's a model law and a model set of model rules that are created. And I've worked on the committee for mobility. I've worked on the committee for to revise the model law and the model rules. And I'm currently on the law enforcement committee nationally. So we all work together, and there is a national standard, but every state has some peculiar deviations from that. Maine's include allowing additional degrees, such as the related science degrees, to be licensed. Some states won't license a related science degrees. Some states, particularly in the South, won't license an engineering technology degree unless they have 8 years of experience before they get licensed. So every state has some peculiarities. Maine does not require specialized knowledge above the national standard. Anyone who meets the national standard can be licensed in Maine, and Maine also permits some additional variations from the national standard.
And a second question is there anything in the FE exam that contains something that work experience would not be able, that you wouldn't be able to gain through work experience?
In the fundamentals of engineering exam, most people say that is really a knowledge-based exam, and that it's, if you're looking on experience only, that it's a harder exam than actually the PE exam. So people who have come out of college, not taken that exam, worked for 20 years, and then had to go back and take that exam because a state that they were applying to required them to go back and take the FE exam, say that it's a much harder exam if you're not coming right out of a knowledge environment at like a university or college.
Thank you.
Representative Geiger.
Thank you, Senator Curry. So I just want to make sure I'm understanding. So it sounds like the engineering profession is moving toward a standard. That standard is a 4-year degree, an FE exam, an additional 4 years of practice, and a PE exam. Is that correct?
That is the national standard, correct.
Okay. So that is the national standard. Maine adopts that national standard, but there are also all these other engineers that have been practicing for a long time who don't meet that standard that most states have found a way to allow to continue to practice. And that's what you're proposing here.
I wouldn't say most states. I would say there's a portion of the states, and it might be as many as half, that permit people in some form or another. Some have a statute that says if when you were licensed, your standards would have met the standards that existed in our state at the time you were licensed, that we will license you. Others have other provisions that are like that. We felt that this version would give our board the most flexibility in addressing those questions, because it would have addressed, for example, the issue of the individual who was trying to get renewed and couldn't, and that resulted in a change in our statute. This phrase would have taken, or this section of statute would have taken care of that. And we did actually try to pass in LD 1165, which was shot down for other reasons. We did try, there was a passage similar to this in that statute.
So I just want to be sure. So we have a standard, we have a way around that standard for those who are already practicing, who followed the standard at the time. We are not in any way decreasing our own standards for new engineers.
That's correct.
Okay, thank you.
Let's see, I'm looking for questions. There we go.
And if I may,
Representative Austin.
Where'd you go?
Go ahead. Let Mr. Jackson finish his thought here.
So somebody asked why 8 years, and that was one of the reasons for making it 8 years, is that we wanted to discourage new engineers from trying to get around the current standard. We want to make sure that this is really about people who've been practicing, who when they were licensed had a slightly different standard.
Thank you. That really clarifies things.
Representative Austin?
Yes, thank you, Mr. Chair. Mr. Jackson, I do remember that gentleman. That may have been what was in the back of my mind when I was concerned about the 8 years. But in this piece of legislation, and perhaps in the past also, will you be able to follow, if you had an individual that does come to Maine, wants to practice here, and has some sort of an anomaly outside of this, does the board still have the ability and the power, I guess you'd say, to be able to consider that and make a ruling?
Well, yes, this statute reserves the authority to the board in given due consideration of the protection of the public. And that's so the authority, the board has the authority to deny licensure if they feel that somebody does not meet the standards.
Thank you.
And I see no further questions. Thank you, Mr. Jackson.
Thank you.
Our next person to give testimony is Ms. Trice-Gill. Go ahead, Ms. Trice-Gill.
I'll unmute. Thank you for this opportunity. Dear honored members of the committee, I'm the founder and CEO of IntWork, a Maine-based diversity recruiting firm, established in 2018 to stem the exodus of foreign trained engineers from the state by matching them with state employers. Maine state employers. I'm speaking in favor of LD 11 that will allow the board to license engineers licensed for 8 years in other states if they were initially licensed without the FE, or if they had a 2-year degree or a 4-year degree, just as David Jackson described. It's a wonderful initiative to grandfather people who were previously licensed in other states. And I'll explain the reason why I support this. At IntWork, I work with many Maine employers who are struggling to fill key roles that, when left open, impede their ability to do business. While IntWork's focus is matching employers with qualified engineers living in Maine, particularly those from underrepresented groups not yet working in those fields, such as minority and foreign trained immigrant engineers, sometimes Maine doesn't have the talent we need, and the employers we work with encourage us to look outside the state. Word of IntWork's free services, guiding and coaching foreign trained engineers to get back in their field, has spread outside of Maine, resulting in frequent applications and inquiries from out-of-state engineers seeking opportunities in Maine. Sometimes those out-of-state engineers are a fit or would be a fit were it not for lack of sufficient reciprocity. In particular, we see a lot of foreign trained engineers who have not yet, who have extensive overseas experience, who then come to the US for a master's and or a PhD, but who are not yet licensed. Or, as is more relevant to this bill, who are licensed in another state, but are not yet eligible in Maine. For instance, in states where by dint of having a PhD, they were able to sit for the PE licensure exam without the preliminary FE exam. Those provisions in other states have resulted in them having an advantage of being able to recruit and retain those engineers. IntWork has partnered with David Jackson at the Bureau of Licensure for Professional Engineers on many workshops and webinars on the Maine state licensure process to educate foreign trained and minority engineers who want to live and work as engineers in Maine on how to pursue professional engineering licensure. And in these process, we've learned and heard many of these stories. Although this provision does not specifically address issues related to foreign trained engineers, unless they have been licensed elsewhere in the US for 8 years, this will help build an important pipeline for future recruitment and incorporation of those engineers licensed in other states into the future Maine economy, allowing our economy to grow, further expand, and compete with other states for those key resources. Thank you for considering this update to the Maine state licensure bill.
And Representative Austin.
Mr. Chair, I'm all set. My hand wants to stay up, even though I sometimes don't want it to. I know that's hard to believe, but.
Representative Collmore.
Thank you, Mr. Chair. I was curious about if there's a way that we could amend this bill to help with licensing of foreign trained engineers. I actually happen to work with quite a few foreign trained engineers, and I was unaware that this is such a battle until just recently for them to get licensure in Maine, even though they may have been practicing for, let's say, 20 years in India, for example. Is there a way that this could be amended to help their process easier, make that easier?
Well, my intention in presenting was just to support the bill, but there is one way potentially, if it were to allow people who have a PE and who have established 8 years experience, perhaps even before they got the PE, then if someone were able to achieve a PE in another state and also be able to establish that previous 8-year experience and meet all the other qualifications of PE recommendations, et cetera, then it would certainly allow us to not wait that 8 years for them to come to Maine from another state. But I would leave that really in the hands of David Jackson and his team. They're really experts at this, and I think that might be something for another time.
Thank you.
But hopefully soon.
Before I go on to the next question, I wanted to check in with our clerk, Ms. Breton. I saw in the chat there is a second interpreter that was wanting to make sure to be promoted to panelists. Are we all set? We're all set. Okay, great. Just wanted to make sure of that. So our next question, Representative Pebworth.
Thank you, Mr. Chair. And this gets back a little bit at the question that was just asked, in that I wonder, and is it Ms. Gill or Ms. Trice Gill?
Ms. Gill.
Ms. Gill, if you could give us even just a minute or two more about the work that you do. We're certainly looking a lot at making Maine a business-friendly place. We're looking at ways to encourage people who have come, whether it's from another state or another country, be successful in Maine as quickly as possible. We know we're looking at needing a lot more educated workforce. And this bill, as Representative Collender just mentioned, seems like an opportunity that we might have in front of us.
Thank you. Well, thank you for this opportunity, Representative Pebworth. IntWork grew out of nonprofit efforts. In fact, it grew out of efforts through another group, the Maine Association for New Americans, that I came to represent to the predecessor of this committee back in 2013 to talk about the barriers for foreign trained professionals to re-enter the field. That proposal turned into ongoing funding for the New Mainers Resource Center, which has been going on since 2014 and 13. But so the work we've done has been to support and to supplement that through intensive coaching and for foreign trained engineers. In fact, David I first met David when I invited him to present to a group of over 30 foreign trained engineers in December 2018. And many of them, what happened is so many engineers come here and they hear from different sources that, well, you used to be an engineer, but you're not an engineer in the US. You need to choose another career. So they get sent for things like high school equivalencies, CNA courses, and other pathways. And there are a lot of myths out there. So partnering in an event with USM and David, we held a big forum with interpreters at many different tables for the different languages they spoke, so that even if they didn't speak English, they could bring the news back to their communities and their peers. We had speakers from USM, SMCC, and David Jackson from the Bureau of Licensure was a keynote speaker. From that, we went into a whole series of, we organized them by specialty in engineering, and then turned each of those specialty groups into a study group to get people on board for licensure. And we held study groups actually here in my office, in my conference room, and in Lewiston throughout the winter of 2019. And then have one big barrier in getting them to actually be able to get licensed has been the cost of the licensure process, not specifically the test itself, which is only $175, but the licensure prep, which, since many of these folks have been practicing engineers for 10 or more years, but they haven't been studying differential calculus, they've been out of school for 10 or more years, it's extremely hard to pass the test by studying individually. So I've gone out and found engineering prep places, negotiated discounts for them. And this is all work I do. My fees are 100% engineer funded. Employer funded. So I get fees when I place a person, but I do all of this work pro bono. So this is all work just to really encourage and retain these folks, because I heard many foreign trained engineers who had been here for 5, 6, 7 years, and they said, I'm moving to Texas because they have easier pathways, or they have, I can get a job there. I'm not getting a job here. I'm still in home health or in a factory. And so it's a passion of mine. And it's really exciting to see employers pick up on this. So we do have many large engineering companies and small and mid-sized engineering companies that are clients. And in order to, since it's hard for people to sometimes figure out, is this equivalent, until they've taken that fundamentals of engineering test. And since that's such a long journey for candidates to get back on the horse and take that exam, one of the things we've also done is provided an option for companies to have a no-fee internship. So whereas recruitment agencies usually charge a fee for everything, we don't charge a fee for referring candidates.
Ms. Gill, I'm gonna ask you to wrap up there,
sure.
Or it might be for another time, but I want to keep us on topic on this bill.
Sorry, I would love to come to present to the group to talk more about that in the future. But there are some very key provisions that could be helped, whether it's funding or whether it's other provisions to be able to help people get back on track. Thank you.
Great, thank you. And we have another question from Representative Austin. Or is that do you have a question?
Yes, I was picking up on the same thing, because we have really done quite a bit of work in the past trying to help the new Mainers engage into their professions here. So I thank our lovely lady for all the work that she is doing, and perhaps we can continue to keep an eye on that and see if we can even help bring more success. Thank you.
Thank you.
Thank you.
Ms. Gill, thank you very much. I'm sorry I butchered your name at the start of this. Thank you for giving testimony. I don't see any other questions from the committee. I'm going to ask Ms. Breton, do we have anyone else seeking to give testimony on LD 11?
To my knowledge, Senator, we do not.
Okay, so with no further testimony, I'll close this public hearing on LD 11. At this point, I'd like to hand the gavel over to Representative Roberts for consideration of LD 18.
Thank you, Mr. Chair. Can you hear me okay? Okay. Okay. I would now like to open the hearing on LD 18, an act to clarify American Sign Language interpreters licensing laws, presented by Senator Curry. Senator Curry, the floor is yours.
Representative Roberts and members of the committee, good afternoon. I'm Senator Curry, and I'm here to represent LD 18, an act to clarify the American Sign Language interpreter licensing laws. This is on behalf of the Office of Professional and Occupational Regulation with the Department of Professional and Financial Regulation. This is a technical fix that is supported by DPFR and the interpreter community. It clarifies the educational and training components required of the conditional light interpreter and conditional deaf interpreter applicants. The board administrator, Jennifer Hawks, is here, and I think I have seen that, is here to give you a more detailed explanation of the bill. I'm happy to entertain questions, but you may wish to defer your questions until after Ms. Hawks testifies. Thank you very much.
Thank you, Senator. Are there any questions for Senator Curry? Representative Austin? No? Okay, let me put your hand down there. Okay. Then I guess we'd like to call next. We have Ms. Jennifer Hawk. Is she here?
Hello, can everybody see and hear me?
We can hear and see. Let's see.
Okay. Thank you, Senator Curry, Representative Roberts, and members of the committee. My name is Jennifer Hawk. I am a regulatory board manager at the Department of Professional and Financial Regulation within the Office of Professional and Occupational Regulation. I oversee several licensure boards and programs, financial management, including the daily functions. This includes the American Sign Language Interpreters Licensure Program. I'm here today to speak in support of the department's bill LD 18 and to thank Senator Curry for agreeing to sponsor this bill. This bill was slated for consideration by the IDEA Committee last session, but unfortunately the legislature did not reconvene because of the COVID-19 pandemic. During the first session of the 129th legislature, legislation was enacted that made changes in the American Sign Language Interpreters Licensing Statute. That legislation became effective on September 19th, 2019 as Public Law 2019, Chapter 284. The legislation was passed and enacted with a small grammatical error that impacted applicants' licensure requirements applying for the conditional interpreting license. Chapter 284, as worded, requires conditional license applicants to show proof of only one component of the education or training in the interpreting process. The original intent was for the conditional license applicants to show proof of meeting both the educational and training requirements. LD 18 corrects and clarifies that applicants applying for a conditional license must meet both the education and the training. LD 18 does not alter any other substantive provisions of Chapter 284. Thank you for your attention, and I'm happy to answer any questions now or at the work session.
Thank you, Ms. Hawk. Are there questions? Representative Austin.
I don't have a question. On my screen, I don't have my hand up, but I do up there by my picture. I can't control that.
I can. Okay. Representative,
you.
Representative Collmore.
Thank you very much. I'm curious about this licensure changes. Not that I think that it's unwarranted, because I think we've seen examples of poor interpreters nationally. But my concern is if we have hearing parents who have learned extensive sign language because their children are non-hearing, would this prevent them from being able to do this, even though they haven't received formal education in the sense of having a college degree or something like that, but they have real world life experience with their interpreting because of their children?
So I believe that the universities that have the ASL programs actually have a way of determining whether or not somebody should be starting at the bottom of the educational ladder, so to speak, based on their history and what they've grown up with in their household. I think also the Registry of Interpreters, the National Registry, also has an alternative pathway that they view work that may have been done outside of school.
Okay, so even if they have that experience in real world stuff, you would still require them to get some formal education requirements. I'm just thinking cost prohibitive wise, education is not cheap. I'm still paying for my school loans. And I actually happen to have a friend whose son is non-hearing and he is hearing, but is very fluent, obviously, because his son can't hear in ASL. And it took him a while to learn. He had to go to courses and stuff to be able to do that. But when his son graduates, if he wants to be an interpreter, it would be wonderful for him to have that opportunity.
Correct. This was the National Registry actually was the first to move into requiring a bachelor level degree. And so Maine is just now getting caught up to what the RID is requiring of national interpreters. So we're just coming in line with what's required at the national level, so that people would be able to go to other states and meet the requirements there. Whereas previously it was just a associate's degree that was required. So this was a move.
Okay, thank you very much.
You're welcome.
Okay, are there any other questions from members? Ms. Breton, are there any additional people wishing to testify on this bill?
To my knowledge, there are no other people wishing to testify.
Oh, someone's raising their hand, an attendee.
An attendee. Oh, that's Ms. Gill.
Hi, I just wanted to speak in favor of this bill. In addition to my current role, I previously oversaw interpreter services for Maine Medical Center, and also
Ms. Gill, you may have lost your audio. I think that she has lost. Ms. Breton, if you could mute her. Oh, there she is.
Hi, sorry, I was switching back to panelists. I just wanted to take a moment to speak in favor of this bill. In addition to my work with immigrant engineers and immigrant professionals, I previously, my previous profession was overseeing interpreter services quality for Maine Medical Center and establishing quality provisions there between the years of 2016 and 2018. And also previously between 2003 and 2009, doing that for the New York City Public Hospitals, establishing interpreter quality. So I just wanted to speak in favor of the bill that Jennifer Hawk presented, and also address the question that Representative Collmore had, which is that the consequences of poor interpreting are great and can result in loss of life and well-being. And so I think that even with the questions and potential burden for people who want to be certified, it's essential to meet those national standards. The cost to individuals and to society otherwise is innumerable. And additionally, with regard to your concern, Representative Collmore, I wanted to mention, even if someone is having been in the position of seeing people come with their family members and having those family members interpret, there are patients always have a right to refuse an interpreter and to use their family member if they choose. Oftentimes a hospital will opt to have an interpreter interpret for the provider in that case and have that person in the room and be able to at least have both parties be able to have their chosen interpreter in the room. So there is no, it would just keep, if a family member didn't have the certification requirements in place, then they wouldn't be able to, once they become certified or once they become qualified in the state, they could go and interpret for anyone. So it's one thing to interpret for a family member, although that isn't the preferred practice. There are cases, I understand, where that might be the patient's choice or the family's choice. And that this would not in any way keep that patient from making that choice, if I understand correctly. Am I right, Ms. Hawk?
Right.
Thank you. So I just wanted to share that since there is no one else here and since I have that expertise. Thanks.
Thank you, Ms. Gill. Are there any questions from the committee? Seeing none, and we have no other parties wishing to testify. Having heard the testimony of those present today, I'd like to now close the public hearing on LD 18 and hand the gavel back over to Senator Curry.
Thank you very much. I wanted, before we get into LD 110, which we're getting ready, and if I'll ask Ms. Breton, if you could bring in as panelists, whoever I think we have, let's see, I think we have 3 in the waiting room or as attendees. If you could bring them all in, that would be great. Typically in the room, we would have a clock which has a 3-minute countdown, so the person giving testimony can see that clock. Just to let the members know and the public know that that technology is being worked on. We expect that one of these boxes in the future will be a clock to give us some advice. And so I will be trying to give people that countdown verbally, so there's a little more flexibility than we anticipate having in the future. But the expectation is around a 3-minute testimony so that we can give everyone their opportunity. So at this point, I want to introduce Representative McCreight to give testimony as the sponsor on LD 110. Welcome, Representative McCreight. The floor is yours.
Thank you very much. Nice to see some old and current committee members and colleagues. Thank you. Senator Curry, Representative Roberts, esteemed members of the Innovation, Development, Economic Advancement, and Business Committee. I'm Jay McCreight, representing Harpswell, West Bath, and Northeast Brunswick in the House. And today I'm here to present LD 110, an act to clarify prepayment requirements in home construction contracts. This bill came to me from a constituent, from actually a couple constituents who had a relative run into a problem and they sought a solution. We expect all home construction contractors to be reliable and responsible, and most of the time that's true. But there are exceptions when contracted work isn't completed or not completed satisfactorily. In such cases, the result is harm to the consumer, even more so if they've already paid the cost of the entire contract amount. By requiring a truly transparent contract payment process, including provisions regarding prepayment or down payment, as we usually call it, we can provide greater consumer protection. My goal in this proposal is to ensure that the consumer is fully informed and aware of their rights when signing a contract. It's not to change the core content of current statute concerning home construction contracts. The situation that brought this to my attention involved an older adult relative of my constituents who was contracting for materials and labor for a new roof. Though the fine print of the contract included information about the maximum prepayment, this was not discussed or in any other way made clear, leaving her with the understandable impression that she had no option but to pay the full amount. I certainly have experienced this myself when going to purchase materials or to sign a contract. And probably others have had the same situation. What's currently in statute is that any home construction contract for more than $3,000 in materials or labor must be in writing and must include certain provisions, one of which is that a down payment or prepayment of no more than 1/3 of the total cost can be required, unless this requirement is specifically waived by the consumer. The prepayment provision was put in place by the legislature in 1987, and this is the provision that's the focus of this bill. There's nothing wrong with paying the entire cost up front if that's what we choose. If all goes well, there's no problem, but having paid in full before work starts, the consumer can lose the entire amount of the contract if things don't go well. As consumers, we need to know our options under the law. The statute is there to protect us from financial harm, but when it's not made clear, we simply aren't fully informed. The proposal before you is that the waiver of the maximum down payment requirement must be provided as a separate document which both consumer and contractor sign, just as both sign the contract. This will highlight the consumer's rights while not preventing anyone from choosing to pay more, including paying the full amount of the contracted price if that's their choice. I want to thank you for your attention, and I'll do my best to answer any questions.
Thank you very much. What questions do we have? I'm going to recognize Representative Roberts.
Thank you, Mr. Chair. Thank you, Representative McCray. Good to see you. You actually gave me a peek at this bill, so I was able to ask around a little. So I just have some questions to kind of get some clarification. Do you want me to fire them one at a time or fire them all?
One at a time, maybe.
Okay. So I guess the first one would be, was this bill introduced out of an abundance of problems that we're seeing with this issue in state, or was it just from one constituent? And is there any data to kind of back that up?
Well, I could get you data. It's certainly not just this constituent. It came to me through constituents, but as I researched the bill, talked to the AG's office, the Consumer Protection Department, clearly, I mean, I've certainly anecdotally heard of it, but there are some recent cases where huge numbers of people have been affected. And I'm not remembering the name of the company right now, but there's a company, this just happened very recently with many, many people affected. And in that case, the Consumer Protection Department is acting on it. If it's not a huge number of people at the same time about a specific company, they may not take it up. They don't. So then you're even more at risk. You know, if it's a big deal and a whole bunch of people are affected, they're probably going to intervene and maybe you get some recovery. But in these smaller cases, it's not likely. Therefore, let's prevent it in the first place, is my goal here.
Yeah, if we could have some kind of data background, on it. And my second question would be in the execution of this. I know with my own personal contractor, everything's online. His quotes are online. I pay online, or, he tells me what it is and I drop him a check and there's no contract signed. So I'm wondering, and I worry if this is the case, if this is going to be more paperwork for our honest contractors, you know, who have, you know, merged to the digital world? Or, you know, how exactly is this going to be implemented, and is it going to put a burden on the contractors?
Well,
I guess is the questions that I'm getting.
Yeah, I am asking that this be clearly something that is not just part of the whole contract. It's separately specified, separately explained. And so if it's you're in person and it's paper, it would be another piece of paper, yes. But my feeling is protecting the consumer is key here, not putting an extreme burden on those wonderful contractors who don't mean ill, but protecting the consumer. So yeah, it would be online, it would be a separate signature or separate initialing, yeah. And again, it's that my intent isn't to say that everybody's out to fool everybody or do bad work, but we know that it exists. Driveway, I mean, infamous cases of driveway sealant that never happens, roofing that doesn't happen or isn't finished, it, you know, on and on and on. But the majority are doing just exactly what they say they're going to do. And fair, you know, it's not to try to be unfair to contractors, but to recognize that people need to know what they're signing. Like in my field of counseling, informed consent is a key principle. And the same idea here, you need to be fully informed.
Do we know what percentage of contractors out there are aware of the 1/3 provision and hold to it?
Well, it's the contract that they present to people. So I would assume they would know it.
Yeah.
And it is in contracts. It's not that it isn't there. It's just not specifically specified. So you sign it thinking, and it isn't explained. So in my experience, you go in to purchase something that's more than $3,000 or contract for something more than $3,000. I've never heard it explained that you didn't have to, you know, you're waiving your right to pay other than full price.
Right.
Which you can do. You can still waive it.
Right. Thank you.
Mm-hmm.
Representative Geiger.
Thank you, Senator Curry. Representative McCray, I have a master's in sustainable design, have built or renovated a couple of houses, but also because of that sort of follow construction in our county, and have to agree with you that I see contractors behaving badly all the time. And there is very little enforcement unless you get a situation like we had recently with a union contractor who basically collected close to $1 million without ever doing any work for anyone. That was unusual that there's actually he is being prosecuted. Most of the time they get away with it. My question is, I wanted to be sure. So the current law specifies 1/3 at the start, and that's in a contract, but you can pay more if you choose to. And what this rule does is make sure that people understand that they don't need to pay more than 1/3, that is the industry standard. And I think that makes a lot of sense because most people have no idea. They may do one renovation in their lives, and they have no idea what the standards are, what best practice is, and they often find themselves having paid the whole amount and then having no recourse when the job is done either poorly or not completed. So I'm very interested in this bill. I love the idea of it. I see people taking advantage of it all the time. So thank you.
Thank you. I'm sorry, my phone just rang. Thank you very much. I appreciate that.
I think we all just jumped thinking that our phones were ringing. So.
Yeah, there used to be a $5 ticket if your phone went off, but I can't help it right now.
Representative Collmore.
Thank you, Mr. Chair, and thank you, Representative McCray. my concern, I saw this coming up and I asked a lot of my friends who happen to be small business owner contractors. They may be the only one in their business. And I do worry about the burden this would be placing on them. And some of them didn't even know this rule existed for the 1/3 payment thing. And I feel like while I want to protect people, I have, my partner actually was the victim of somebody requiring him to pay up front the whole thing. They did the job. It was a very poorly done job. However, I don't think that this requirement would have made a difference. It was in this case, because it was a smaller job, thank goodness. It was patching our commercial properties driveway. But what the concern that's been brought to me too is when the cost of materials exceeds 1/3 the cost of a project. For example, we are working with a contractor to build a garage for us. And his rates, because he happens to be a friend, are much lower for us than what would be the normal cost for other people. But he would, as a contractor, still have to provide this to us, and 1/3 wouldn't even cover the $30,000 for materials in order to build the garage. That's your foundation, your cement, your work, your wood, the roofing, all of that stuff. And I worry what will happen is the opposite effect, that these contractors will order all of this supply work, and then the consumer, the customer, backs out, and there's no protection for them because the law is they only had to provide 1/3. And while most contractors can reuse certain materials, that's not always the case, especially if they've already started the project. And I know there are law recourses and things that small business owners can do to try to recuperate that, but I also know that it's just as hard for them to get that money back, and sometimes cost more than the money that they lost to try to fight those in court. And the other question I have and concern I have is who is actually going to monitor and enforce these new guidelines? I mean, we can pass it, but again, I talked with small business owners who didn't even know the original 1/3 thing existed in the first place.
Mhm.
And so are they going to get fined and in trouble if they don't even know it exists?
Well, that's a lot.
And
Thank you.
I want to, before you jump in on that, I want to remind everybody, all the representatives and senators here, to be careful. It's really easy to slip into work session. And the purpose here is around questionings and making sure that we're asking the clarifying questions and getting as much. And I know we're doing, it's easy for us to do this, and we're setting kind of our pattern here. So let's just be a little careful about when it might be, we're going to start advocating for and against, and try to leave it back to questions. So I'm going to take that, Representative McCray, but you have a question before you, so I wanted to make sure you had the opportunity to answer.
Yeah, I think my response would be that the protection of the consumer is important. It's part of state law that there is a format for protecting consumers. Under the Maine Unfair Trade Practices Act, we have the AG's Office of Consumer Protection. And I think that, perhaps part of the issue is if contractors don't know about this, then they're not probably reading their own contracts, or their contract isn't appropriate. So raising awareness, I think, would be a good thing for everybody's sake. And again, by signing the contract now, you're already waiving that 1/3 prepayment requirement. You can pay more. So I think it would just open up the conversation between the contractor and the consumer that this is what the law is. However, my materials are going to cost this. I'm asking you to do this. And some contractors operate on a percentage basis. So you do a chunk of the job. They charge a percentage. There are different ways that contracts are done. This is simply to make sure that in those cases where it's above $3,000 and a waiver is a requirement already in law, that it's clearly specified to the people who are contracting. And as you're pointing out, maybe the contractors. So I'm surprised to hear that they wouldn't know, but if they don't, they don't. So let's make sure they do. Thank
Representative Ducharme.
Thank you. My question was, I kind of piggyback on Representative Collimore's question. Who's going to police it and who's going to generate the contract? Experientially, I spent a whole lot of time in my previous career doing residential construction mortgages. And probably the number one difficulty I have had in dealing with contractors building $500,000 houses is getting them to complete a contract that complies with state law for building contracts. And these are people building huge houses, general contractors. I'm concerned that we make a rule that the guy with a magnetic sign and a hammer on the side of his truck is never going to abide by, even if he does know about it. I've done a bunch of home equity loans, and I say, bring me in your contract with your builder to redo your kitchen, and it comes in on a 5x8 sheet, rebuild kitchen, X amount of dollars, period. And I've seen that more than I've ever seen any other long drawn out contract with a third, or whatever.
Mm-hmm.
So who's going to police it? Who's going to generate the contract? And who's going to let the contractors know?
Well, this doesn't change what's already in law. Those provisions are already in state law, the 1/3 requirement. The contract is already in law. If people aren't following it, then perhaps we need to let the AG know that this isn't being followed. But that wasn't the problem I was trying to attack. If the committee chooses to take that up, great. However, this is preventative. My thought here is that if we can prevent problems from happening in the first place, people don't end up going to court. The AG's office will have fewer complaints, and those that they do choose to take up, they'll take up. But the smaller ones, they're not so likely to take up. So let's prevent it in the first place. That's my intention here.
But requiring the people to sign a waiver that somebody has to generate is going to open up a real can of worms as far as who's writing it and what does it say. I think Representative Hassenfuss probably can speak to that, but it just be careful what we make in law that other people have to abide by.
Well, I would just respond that I'm not seeing this as, I've talked to the AG's office multiple times about this. This doesn't change what's already there, other than to say the waiver you're already signing has to be clearly specified. In those contracts, you're already signing it. You just don't know you are because it's not separated out.
Representative Hassenfuss.
Thank you, Representative McCray. Can you hear me?
Yes.
So I think you might have already answered my question with your last statement, but I'm curious as to how this amendment to the law changes it from what it already is. In that 1489 already states that parties to a home construction contract may exempt themselves from the requirements of the chapter only if the contractor specifically informs the homeowner or the lessee of his rights under this chapter, and the parties then mutually agree to a contract or change order that contains the parts that they're agreeing to change. How does your proposed bill essentially garner somebody more protections than what the law already gives them?
My response is that if it's clearly spelled out, I suggested a separate piece of paper or separate category digitally. They would know what they're waiving. I think it's a rare case where the consumer knows that by signing the contract, where that even in the fine print, it says you only have to pay a third. They don't know that that's what they're signing. So the idea is to make what's already in law transparent.
Are you saying that you would like to further clarify what specifically informs means for an obligation on the contractor?
Well, I think that would be a way you could put it, that fully informed means it's separately explained, separately signed. When you're signing it, I would assume it would have to be separately explained.
Thank you, Representative McCray.
Thank you.
I'm looking to see if we have any other questions for Representative McCray. Great.
And I'm hoping you have at least one other person who was going to speak on the bill.
I think we do. So thank you very much. Appreciate
Thank you.
it. And Ms. Breton, can you bring in, let's see, we have 2 attendees. And are any of them speaking on this bill?
No, Mr. Henderson is already in. The attendees, one of them is the audio.
Gotcha.
And the other one is Ms. Foy, who's waiting for the budget, I believe.
Excellent. So our next person to give testimony is Mr. James Henderson.
Thank you very much. Can you see and hear me?
We can only hear you. Are you able to turn your camera on?
Well, I thought I did. So I can see myself, but that's not going to count.
I'll see if I've
start my video. Let's see what that happens.
That sounds very promising.
Co-house. Yeah. Somebody says start my video and I click that.
There you go. We can see you now.
Okay.
Welcome. The floor is yours.
Thank you. Senator Curry and Representative Roberts and esteemed members of the Innovation, Development, and Economic Advancement and Business Committee. As you already know, my name is Jim Henderson. And by the way, that acronym is obviously very appropriate for your committee. I'm here to ask you, though, to clarify the intent of the, quote, home construction contract statute that intends to protect homeowners from unreasonable advance payments for construction costs over $3,000. LD 110 will ensure that the homeowners do not have to pay the full amount of construction costs in advance unless they're clearly, and again underlined, informed that they have the right to pay no more than 1/3 of the quoted cost in advance. If the homeowner and contractor agree to full payment, and that agreement must be in writing, it's signed by both parties, then they can allow themselves to pay more. I know that the Attorney General's office has received many consumer complaints from people who are out the full amount of the contract when things go wrong, but who have already paid in full and cannot recover their money. Making it clear that the waiver of the 1/3 payment limit is an option, not a requirement, can be expected to result in fewer losses for consumers and fewer complaints to the Consumer Protection Division. Thank you very much for your consideration on this.
Mr. Henderson, I didn't get where you're from or if you're associated with an organization. Would you mind sharing that with us?
Oh, yeah, I am from Harpswell, and I am an alumni of state government in the House.
Great. Thank you very much. Thank you very much. Do we have any questions for Mr. Henderson? Representative Austin. Representative Austin, I think you're still muted. There you go.
Okay. My question, thank you, Mr. Chair. My question would be, and I really meant to address this to Representative McCray, but obviously the AG's office is a certainly a source of information on this issue, but was there any contacting of Ms. Head over in Commissioner Head, has oversight on licensure, and we've gone over these issues many times, and I wondered if there was any interaction with that office, if anybody could. And also, the question has come to me from a builder who's listening, is the, and I heard Representative McCray reaffirm it about the $3,000, and the question was that the some in the public thought that we had raised that a little bit higher than the 3,000 in the past. So I don't know if either or could answer or address those two very convoluted questions.
Mr. Henderson, do you have a response to either of those questions?
I guess the thing is that the reason I and my brother-in-law wanted to talk to Jay McCray on this was that we got into this brother-in-law conversation going back and forth, and the bottom line was, if there is a statute that is intended to protect people from overpaying unless they otherwise make arrangements, that is just a toothless statute. So it's supposedly for protection, but it apparently at some degree does not give the complete protection.
Thank you.
Are there other questions? No, seeing no other questions. And I'm gonna check in with the our clerk, Ms. Breton. Are there any other folks here to give testimony on this bill?
Do not believe so, Senator.
Okay, excellent. Seeing no other questions for this bill. No other testimony. We're going to declare this public hearing closed, and thank both Representative McCray and Mr. Henderson for giving testimony this morning. So the public hearing on LD 110 is closed.
Thank you.
At this point, we're going to take a 5-minute break, and we will return to begin our work session. And the work session will be on the budget review that we need to give our recommendations back to the Appropriations Committee. So actually I said 5 minutes, but I want to check with our analyst. Do you have, is 5 minutes enough for you all to get set up?
Absolutely. Yep.
Excellent. So we'll take 5 minutes and we will return. We'll make it 6 minutes. So we return at 11:15. So thank you very much. Please remember to turn off your camera and your microphone. Welcome back, everybody. We're opening up our work session for to review of the governor's budget and for the supplemental. And to start off, we are going to ask our OPLA analysts to walk us through the budget as a process goes. They're going to, I'm also going to ask Ms. Breton to welcome into the panelists. I think it is both William Norbert, Bill Norbert, and Ms. Foy. So as process goes, our plan is to go through the items one by one, and Rachel, Ms. Olson, Mr. Semp, who will be leading this, or will both of you be doing it?
I'll be doing it today.
Okay, and for this one, we'll be sharing our sharing the screen. Is that correct?
It is. So
Okay.
if I go ahead and do that.
Please go ahead.
All right. Thank you, Senator.
My intention is that we'll go through one by one. Mr. Semp, and then either and then give an opportunity for both either or both of Ms. Foy and Mr. Norbert to speak.
Thank you so much.
Explain.
So just to review the process here, we have a series of initiatives, and I will refer to each initiative by the reference number here. So this first one is reference number 148, initiative 148, and the committee will vote on each of these initiatives. Then after the vote is done, I will prepare a letter and attach the votes to that letter, and then transmit that letter with the recommendations of the committee for each of the initiatives to AFA. And AFA will consider the recommendations of this committee in making their final determination on this supplemental budget. So my plan is to go through each of the initiatives one by one, and then if committee members have questions on any of the initiatives, we have here Kate Foy from DECD and Bill Norbert from FAME, who might be able to help us with some of those questions. We also have Rachel Tremblay from OFPR, who is the assigned budget analyst for this committee, to help as well. So I will go ahead and get started with reference number 148, the first one here on the screen. And all of these at the beginning, all except actually for the last initiative, fall under DECD. And these are, as I think I explained before, these are all curtailments. Each of these initiatives is a curtailment. So it is a reduction that has already occurred per financial order in the fall. So this first initiative, 148, reduces funding to reflect projected actual expenses for contract payments to the Maine Manufacturing Extension Partnership. This does not, there's no adverse impact is expected here, and there has been a reduction in federal match for this initiative as well. And this is in the amount of $50,000, this curtailment. So I will pause there if anyone has any questions about this initiative.
I'm looking for, I'm going to ask Ms. Foy if you can speak to this at all.
This is one of those funds that is a pass-through. So we provide funding, and I would say a lot of what you're going to see around some of this pass-through money with reduced funding, we worked closely with our partners. Some of them received additional federal funding due to COVID. So these are one-time curtailments as we looked at our general budget to find different ways to cut back in spending in response to reduced revenues. This is one of these sort of contractual pieces of the budget where we provide funding to this organization. We worked with them ahead of time to make sure there wouldn't be adverse impacts on the work that they do. So everyone has already been made aware of any of these cuts. We work directly with each organization.
Okay. And Mr. Senft, if you can unshare for a second so we can see everybody, that'd be great. I know the share views are much more challenging sometimes than the unshare. At this point, is there any, let's see, do we entertain a motion to, I want to check on process, entertain a motion to for this first curtailment, this first reference.
So moved.
And a second?
Second.
Okay. Any discussion? Seeing no discussion. Representative Austin, do you have a question? Representative Austin, are you with us?
I am.
Okay.
Believe it or not, I'm right here.
Can you share your screen, please?
I don't, what do I hit?
Here, I will click on invite.
Do it. I don't dare touch anything.
Well, now you should have something to click.
Where? Oh, just start my video?
Yeah.
Oh, okay. I didn't know that. Okay, perfect.
There you go.
You.
We'll need
Okay.
that for the vote anyway.
I just wanted to ask Kate, can you remind us who is the head of the manufacturing at this time?
I can Google it really quick while we're talking and find out that, but I don't know off the top of my head.
Would it be Kathy? I'm trying to bring her name up. That's terrible. I know her well, and I can't bring it up. And secondly, could I politely ask Sam to speak up just a little bit? He is one of the softer presenters that we have. So I'm hanging right over the computer so that I can hear him good.
I sure will.
Thank you, dear.
Representative Geiger.
Thank you, Senator Curry. I just wanted to clarify as I looked at that part of the budget that the reason this is being suggested is that it had previously served as a match to federal funding, and the federal government is no longer requiring a match over the next 2 years because of COVID. Do I have that right?
And it's part of the budget curtailment process. So we went through and worked with each one of these partners to every single person that we either are contractually or statutorily required to give funding to, and or a budget allocation for a specific organization that we pass through funding through. Each one of them received a conversation with the commissioner or deputy commissioner around these curtailments. And yes, some of them did receive additional federal funding, so it was not as impactful.
Representative Hassenfuss.
Thank you, Ms. Foy. And I'm going to have the same question probably for every line item on here, but my question is, can you just explain on each of those what the reduction in funding will cause? So for instance, if there's a $50,000 reduction in funding, but the federal government gave $50,000 in coronavirus relief, then it's a wash. There's nothing there. Or if there's a reduction 50,000 and you've had a discussion with that entity and they've said, well, what we're going to do is X, Y, and Z. If you could, to the best that you know, if you could just sort of explain what the cause of the reduction will have on that agency or entity, it'd be helpful for me.
Sure, I can't necessarily. I didn't have those particular conversations, and I would say that each individual organization would need to speak to that themselves. I don't know exactly what each organization did to make up for that funding, or how it impacted their bottom line, in the sense that, I can't speak to the decisions they made for their own organizations on how that was impactful for them. But again, folks, I think organizations knew this was coming. And knowing that it's a one-time curtailment at this point, people felt like they could absorb that into their own budgets. But what their reactions were and how they handled that, we don't oversee their budgets or their decisions and in their business model, so I can't speak to what they would have done.
Have you had any that have said we really can't sustain this cut, or have they all said we can make this work?
Everybody was in cooperation and felt that they could make it work.
Okay.
Yeah, we didn't close down. Nobody is going into a failure model due to these curtailments. They weren't. I don't think that we certainly aren't the only funding source for many of these organizations. So it wasn't that when they lost our funding, they didn't have any funding.
Seeing no other questions, I'm going to call the vote. I'm going to ask Ms. Breton if you could call the vote. And for this, I think everyone's camera is on, so we're good.
We need a roll call vote then?
We need a roll call vote. Mr. Senf, you're looking like you were going to jump in and say something.
You could do a roll call vote, or you could do, well, we should probably do a roll call vote because then we have the oral, but I think you could do a show of hands, but if it's easier to do a roll call to get everybody.
We'll do the roll call vote. Okay.
Representative Geiger.
We're going to start the vote now. I noticed Representative Andrews has his hand up. I didn't know if he wanted to add to the discussion before we voted.
Just a
Representative
question to clarify this.
Yeah, Representative Andrews, go ahead, and I'm gonna ask Ms. Breton to stop for a second, and because I did not see that, thank you, Representative Andrews.
Just a question to clarify. This is a vote in favor of curtailment, correct?
Correct. The vote is in favor of the motion is in favor of the curtailment that was proposed.
Thank you.
Thank you for that clarifying. Go ahead, Ms. Breton.
Representative Geiger.
Voting in favor of the curtailment. Thank you.
Representative Geiger, yes. Representative Andrews.
Aye.
Representative Andrews, could you say that again?
Yes.
Thank you.
Representative Andrews, yes. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Collmore.
Yes.
Representative Collmore, yes. Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Seaway, absent. Representative Ducharme.
Yes.
Representative Austin.
Yes.
Representative Austin, yes. Representative Hassenfuss.
Yes.
Representative Hassenfuss, yes. Representative Bailey.
Yes.
Representative Bailey, yes. Representative Bernard.
Yes.
Representative Bernard, yes. Representative Roberts.
Yes.
Representative Roberts, yes. Senator Curry.
Yes.
Senator Curry, yes. That would be 12-0 with one absent.
Thank you. Mr. Semp, back to you.
All right, I'm gonna screen share again here. Great. So the next initiative is reference number 149. So this initiative reduces funding to reflect expenses for staff travel and conference support within DECD. And there's savings because folks aren't traveling. So no adverse impact is expected there.
I'll entertain a motion to support this curtailment.
So moved.
Second.
Moved by, I recognize Representative Pebworth, and a second by
Jack.
Mr. Representative Ducharme. Any questions or discussion? Seeing none. Ms. Breton, would you call the roll?
Representative Geiger.
Yes.
Representative Geiger, yes. Representative Andrews?
Yes.
Representative Andrews, yes. Representative Pebworth?
Yes.
Representative Pebworth, yes. Representative Collmore?
Yes.
Representative Collmore, yes. Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Seaway is absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
Yes, my apologies. I have a clown walking through the kitchen here. Just disregard that, okay? I can't move and I can't reach it.
Representative Austin, yes. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard?
Yes.
Representative Bernard, yes. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. That would be 12-0 with 1 absent.
Thank you very much. And thank you all for your patience. I know we would, in the room, we'd be able to just raise hands, but this is how we've been instructed to do it. So back to you, Mr. Senf.
So we are on reference number 162, initiative 162. This initiative reduces funding for contract expenses for the Applied Technology Development Center system. This provides early stage development of technology-based businesses. Again, there is no anticipated adverse impact, and the amount of the reduction is $17,884.
All right. Can we entertain a motion to recommend this, entertain a motion to recommend this curtailment?
So moved.
So moved.
I, Representative Pebworth and Representative Ducharme seconding. So any discussion? Seeing no discussion. Ms. Breton, would you call the roll?
Representative Geiger?
Yes.
Representative Geiger, yes. Representative Andrews?
Yes.
Representative Andrews, yes. Representative Pebworth?
Yes.
Representative Pebworth, yes. Representative Collmore?
Yes.
Representative Collmore, yes. Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Seaway is absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
Yes.
Representative Austin, yes. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard?
Yes.
Representative Bernard, yes. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. 12-0 with 1 absent.
Thank you. Mr. Senf. Senf.
Either way.
Thank you.
So we're on reference number 151. This initiative reduces funding to reflect projected actual expenses for consultation services for forest products. So this is work that has been redistributed to existing department staff, and no adverse impact is anticipated, and the amount is $122,587.
We'll entertain a motion to recommend this curtailment.
So moved.
Representative Ducharme moved. Is there a second?
Second.
Second.
Representative Roberts seconded. Any discussion? Seeing no discussion, Ms. Breton, would you call the roll?
Representative Geiger?
Yes.
Representative Geiger, yes. Representative Andrews?
Yes.
Representative Andrews, yes. Representative Pebworth?
Yes.
Representative Pebworth, yes. Representative Collmore?
Yes.
Representative Collmore, yes. Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Seaway absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
Yes.
Representative Austin, yes. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard?
Yes.
Representative Bernard, yes. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. That's 12-0 with one absent.
We are on initiative number 152. So this initiative reduces funding by freezing a vacant public services coordinator 2 position. So that means that it's currently vacant, so it's not being hired into. This anticipates saving $131,876, and work for this that would otherwise have been done by this position has been distributed to existing staff.
Any questions for either our analyst or for our guest, Representative Collmore?
Hi, thank you. Being sensitive to somebody who has had a job underneath me frozen and having to take on those responsibilities, I'm concerned about the effect that this will have on the department and the staff's ability to do their own work in addition to the missing positions work, and how long we're freezing this position for.
Ms. Voigt, can you address that?
Sure. I think DECD is a small but very mighty team, and we, while certainly would appreciate having the position at this point, we've been able to easily absorb that. Well, I won't say easily. We've just been able to absorb that work in the Office of Business Development team. A lot of the focus in the last, now 11 months has been on COVID response. As we start to move into recovery and working with businesses to either come to Maine or expand, that obviously will need to be reevaluated. But at this point, the Office of Business Development is operating at full capacity, and we have just pulled together to make up for that position.
So how long is this being held for? Is this just that it wasn't filled last year, or are you unable to hire in 2021 as well?
Sam, do you have the answer to that? I'm not sure, and I can quickly find out before we get through this whole process. I'll shoot a text over to the deputy commissioner and find out if that position comes back in the next budget cycle.
Might defer that question to Rachel Tremblay.
Oh yeah, Rachel probably knows. That's true. I forgot she was on. Sorry.
Rachel, can you address that? Ms. Tremblay.
I can't for that specific position. I can research it as well. I would just say by looking at the numbers, it's probably a position that has not been filled in fiscal year 21. And the intent is that it remains unfilled until June 30th, the end of this fiscal year. I can research to see if the biennial has an initiative that continues to hold that position vacant. That's not something I can say right off the top of my head, but the intent, it seems, is that it's a one-time, it'll remain vacant until the end of this fiscal year 21. And I will look into seeing whether the biennial also holds it vacant. So
I actually just got the answer. So it is intended that we will end the freeze on that position at the end of this fiscal year, that it was a curtailment savings one time, and that we will put out to hire for that position and fill that at the end of this fiscal year.
Great, thank you very much.
It's a very important role for business attraction and expansion as we move into recovery and look towards continuing to implement the strategic plan.
Representative Pepworth.
Thank you, Mr. Chair. Ms. Voigt, could you give us just the briefest description of that job?
That job, they will be working on, sorry, I have two screens. It's not that I'm not looking at you, but I've got a screen with all of the testimony that we gave to the Appropriations Committee. So they will be working directly in our Office of Business Development and working on business attraction and also offering resources to those businesses who are looking to expand in Maine.
Can I see no other questions? Can I entertain a motion to recommend this curtailment?
So moved.
Second.
I saw it was Representative Bernard moving. No, it wasn't. Was that Representative Callamore?
That was me. Yes.
You're right next to each other on my screen. So, and then second by Representative Ducharme. Any further discussion? Seeing none. Ms. Bratton, would you call the roll?
Representative Geiger?
Yes.
Representative Geiger, yes. Representative Andrews?
Yes.
Representative Andrews, yes. Representative Pebworth?
Yes.
Representative Pebworth, yes. Representative Collmore?
Yes.
Representative Collmore, yes. Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Seaway, absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
Yes.
Representative Austin, yes. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard?
Yes.
Representative Bernard, yes. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. That's 12 no, 1 absent.
Mr. Seneff.
So the next initiative is Initiative 154. And this again is freezing of a currently vacant position. This is a Planner 2 position. And this is anticipated to save $22,346. And the reason it looks low for a position is because it's 25% general fund and 75% federal funds. That's why that number is lower.
Are there any questions? Representative Collmore.
I would just like to clarify with the last position, that is just until the end of this fiscal year, and it will be able to be hired in the next fiscal year. Is that correct?
That's correct.
Great, thank you.
Any further questions? I'll entertain a motion to recommend this curtailment.
So moved.
Representative Bailey, a second by, I missed who seconded. Representative Bernard this time. So it's moved and seconded. Any questions or any debate? Seeing none. Ms. Bratton, can you call the roll?
Representative Geiger?
Yes.
Representative Geiger, yes. Representative Andrews?
Yes.
Representative Andrews, yes. Representative Pebworth?
Yes.
Representative Pebworth, yes. Representative Collmore?
Yes.
Representative Collmore, yes. Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Seaway, absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
Yeah. Yes.
Representative Austin, yes. Representative Hassenfuss?
Yes.
Representative Hassenfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard?
Yes.
Representative Bernard, yes. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. That's 12 nothing, 1 absent.
The next initiative is Initiative 156. This initiative reduces funding by a curtailment for managing of contract expenses. And it's related to international business recruitment. No adverse impact is expected. This is an amount savings of $116,820.
Are there any questions for our analyst or our guest? Seeing no questions, we'll entertain a motion to recommend this curtailment.
So moved.
So moved from Representative Ducharme and seconded by Representative Geiger. So any discussion? Ms. Breton, will you call the roll?
Representative Geiger,
Yes.
Representative Geiger, yes. Representative Andrews,
Yes.
Representative Andrews, yes. Representative Pebworth,
Yes.
Representative Pebworth, yes. Representative Collmore,
Yes.
Representative Collmore, yes. Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Seaway, absent. Representative Ducharme,
Yes.
Representative Ducharme, yes. Representative Austin,
Yes.
Representative Austin, yes. Representative Hassenfuss,
Yes.
Representative Hassenfuss, yes. Representative Bailey,
Yes.
Representative Bailey, yes. Representative Bernard,
Yes.
Representative Bernard, yes. Representative Roberts,
Yes.
Representative Roberts, yes. Senator Curry,
Yes.
Senator Curry, yes. That's 12-0 with one absent.
Mr. Seneff.
The next
And give me a heads up, how many more are,
let's see,
I don't,
we
I'm
have-
following you.
About half dozen.
A half dozen more?
Yeah.
Okay.
So with reference number 160, so this is a reduction in contract expenses that relate to administrative services to support the Economic Growth Council provided by MDF. $5,540 savings.
I have a question for you, Mr. Seneff.
Yes.
Are we permitted to combine the rest of these on parliamentary? Is there a prohibition for combining them?
I think you could combine them if the catch would be if the vote has to be the same then for all of them.
It has to be the
So
same.
if there was a different vote on one of them, that would throw
You're
around
right.
some things.
So I think we're going to move ahead as we have been, just to so we don't have to get into that. So, okay. So, any questions for our analyst or our guest on this one? Seeing none, I'll entertain a motion to recommend.
So move. Second.
I saw Representative Ducharme as the second, and who was the first?
I was.
Representative Pepworth, thank you. Any question, any discussion? Ms. Breton, will you call the roll?
Representative Geiger,
Yes.
Representative Geiger, yes. Representative Andrews,
Yes.
Representative Andrews, yes. Representative Pebworth,
Yes.
Representative Pebworth, yes. Representative Collmore,
Yes.
Representative Collmore, yes. Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Seaways, absent. Representative Ducharme,
Yes.
Representative Ducharme, yes. Representative Austin,
Yes.
Representative Austin, yes. Representative Hassenfuss,
Yes.
Representative Hassenfuss, yes. Representative Bailey,
Yes.
Representative Bailey, yes. Representative Bernard,
Yes.
Representative Bernard, yes. Representative Roberts,
Yes.
Representative Roberts, yes. Senator Curry,
Yes.
Senator Curry, yes. That's 12-0 with one absent.
The next initiative, again, reduces contract expenses. This relates to the Maine Small Business Development Center. And this is an instance where federal CARES Act funding actually helped fill in the gap there. Funding wise, the reduction is $68,368.
Are there any questions for our analyst or guest? Seeing none, I'll entertain a motion to recommend this curtailment.
So move.
Representative Ducharme,
Second.
recommended. Second from Representative Collmore.
From me.
Thank you. Any discussion? Ms. Breton, will you call the roll?
Representative Geiger,
Yes.
Representative Geiger, yes. Representative Andrews,
Yes.
Representative Andrews, yes. Representative Pebworth,
Yes.
Representative Pebworth, yes. Representative Collmore,
Yes.
Representative Collmore, yes. Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Seaways, absent. Representative Ducharme.
Yes.
Representative Ducharme, yes. Representative Austin.
Yes.
Representative Austin, yes. Representative Hassifus.
Yes.
Representative Hassifus, yes. Representative Bailey.
Yes.
Representative Bailey, yes. Representative Bernard.
Yes.
Representative Bernard, yes. Representative Roberts.
Yes.
Representative Roberts, yes. Senator Curry.
Yes.
Senator Curry, yes. That's 12-0 with one absent.
Mr. Senator.
The next initiative here relates to the is 166, reduces funding for contract expenses related to the Maine Workforce Opportunities Marketing Fund. There is expected to be a marginal impact on workforce attraction efforts. And just as a note, this is a program that does actually sunset in March of this year, and we're looking at a $5,000 reduction.
Any questions for our analyst or guest? Seeing no questions, I entertain a motion to recommend this curtailment.
So moved.
Second.
Geiger and Representative Ducharme. So, any discussion? Seeing none, Representative, Ms. Breton, would you call the roll?
Representative Geiger.
Yes.
Representative Geiger, yes. Representative Andrews.
Yes.
Representative Andrews, yes. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Collmore.
Yes.
Representative Collmore, yes. Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Seaway, absent. Representative Ducharme.
Yes.
Representative Ducharme, yes. Representative Austin.
Yes.
Representative Austin, yes. Representative Hassifus.
Yes.
Representative Hassifus, yes. Representative Bailey.
Yes.
Representative Bailey, yes. Representative Bernard.
Yes.
Representative Bernard, yes. Representative Roberts.
Yes.
Representative Roberts, yes. Senator Curry.
Yes.
Senator Curry, yes. That's 12-0, one absent.
The next initiative is 164, and this is a reduction in contract expenses to the Maine Technology Institute. And this is an amount, a reduction of $336,515.
Do we have any questions for our analyst or our guest? Representative Collmore.
This seems like a large curtailment. What is actually being affected and cut as this in this over $300,000 curtailment?
Ms. Boyd?
It's represents about 5% of their funding that they receive from us. They do receive funding from additional resources, and we worked with Brian Whitney and in working through this, and has not been impactful in the work that they're doing right now. And it's a one-time reduction, so it won't be in the next round of the budget process.
Are there
Thank
any
you
other?
very much.
Yeah.
Representative Austin.
Kate, I'm sorry, that last sentence, you said it's a one-time and it won't be in the next one?
Right, that cut is not reflected in the biennial budget that was submitted. So these are all one-time, never easy to make these decisions or curtailments, but this is a one-time curtailment that we've asked everyone for.
And it's what percent? It
represents 5.12% of a reduction. So.
And Ms. Boyd, can you tell me what was the overall budget curtailment that with everything? Is that higher or that's lower than the overall curtailment, correct?
Yeah, the overall curtailment was $963,000. Well, $963,625. So it was DECD's budget represents a very small piece of the overall state budget. So it was, again, while never easy to do, to have curtailments, we were able to find these funds with relatively low impact on the work that we're doing and that our partner agencies are doing.
Any other questions for our guest or analyst? Seeing none, I'll entertain a motion to recommend the curtailment.
So moved.
Seconded.
I saw that moved by Representative Ducharme and seconded by somebody. Thank you, Representative Bernard. Any further discussion? Seeing none, Ms. Breton, would you call the roll?
Representative Geiger?
No.
No. Representative Geiger? No. Representative Andrews?
Yes.
Representative Andrews? Yes. Representative Pebworth?
Yes.
Representative Pebworth? Yes. Representative Collmore?
No.
Representative Collmore? No. Senator Lucchini?
Yes.
Senator Lucchini, yes. Senator Seaway, absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
No.
Representative Austin, no. Representative Hasselfuss?
Yes.
Representative Hasselfuss, yes. Representative Bailey?
Yes.
Representative Bailey, yes. Representative Bernard?
Reluctantly, yes.
Representative Bernard, yes. Representative Roberts?
Yes.
Representative Roberts, yes. Senator Curry?
Yes.
Senator Curry, yes. So we have 9-3 in favor, 1 absent.
Senator Curry, can I just say one thing about this?
Sure, go ahead.
Thank you. Sorry, I know research and development and investment in innovation is extraordinarily important, especially as we look towards our recovery from COVID-19, and we worked very hard to only curtail this particular budget cut by 5%. So I certainly appreciate the concerns, but just wanted to make sure everyone on the committee understood, as the committee is charged with innovation, that this is something that was very challenging for the department to do, and a hard decision that we were decisions that we were asked to make from the administration around curtailments versus cutting in other ways. So I appreciate the discussion and look forward to finding innovative ways to support our innovation and moving forward in recovery. So,
Mr. Senator.
So we are on the last one, and this is
1 second, Mr. Senator. Was Representative Austin, were you trying to speak before we shifted over?
Yes, I was. Thank you, Mr. Chair. Kate, I really appreciate that. And I think as much as we can, we have an appreciation for the intense work that this has been. But, Sunday, Blue Shift Aerospace launched the most incredible rocket and the first of its kind in the world. And knowing that they were receivers of support through MTI. I just can't let this vote go without recognizing that impact. We have no idea at this moment what kind of impact that is going to have on our state. And if you just look at that one gorgeously golden nugget, I just have to put a place marker down to say how important this is. And our department is already so small that it's just my one little token.
I appreciate that, Representative Austin. Blue Shift is in Brunswick, where I live and now represent on the town council. So it was very exciting here.
Unbelievable. Thank you.
Very exciting to watch as well. So, okay, back to you, Mr. Senator.
so we are on our last initiative. This initiative is a FAME initiative. And before I get into this, I just wanted to note, folks might see that the waste motor oil program is not here as an initiative. I know that you saw it on the budget. So that has apparently been moved over to ENR. So that is not something that this committee will vote on. I just wanted to say that in case folks noticed it wasn't there anymore. So this FAME initiative, this is Small Enterprise Growth Fund. It reduces funding by managing contract expenses within available resources. And it is a reduction of $50,000.
And do we have any questions for our guest? And I notice we have Bill Norbert, who is on in our work session. Are there any questions for any of our analysts? Go ahead, Representative Collmore.
I'm curious how this is going to impact FAME and their ability to continue doing all of the great work that they do over the next 5 months before our new fiscal year.
Thank you, Representative. Good afternoon, everyone. This won't affect FAME at all. This is pass-through money to our partner, the Maine Venture Fund. And this represents a 10% cut to their $500,000 appropriation. It is a curtailment. They have already absorbed this into their budget. It just means there'll be fewer dollars, $50,000 fewer to invest in promising Maine companies, which is what it does. But they are prepared to accept this. It won't affect staff. Happily, the governor's proposed biennial budget doesn't propose any cuts to their line, and we hope you'll help us keep that.
Thank you very much.
So as I understand it, this is the fund that they use to invest in companies, and they will have $50,000 less of their fund that that they decide, but you all manage, correct? With FAME?
Correct, Senator Curry.
Thank you. Senator Lucchini.
Thank you, Mr. Chair. And I think between Representative Collmore and yourself, you may have clarified it, but this would reduce the investment fund by $50,000. So that's $50,000 less dollars we can buy equity stakes in Maine businesses.
Correct, Senator.
Are there any other questions for any of the analysts or for our guest? Seeing none, I'll entertain a motion to recommend the curtailment.
Moved.
Second.
Moved by Representative Geiger, seconded by Representative Ducharme. All right, is there any further discussion? Representative Geiger, are you trying to say something?
Yes, thank you,
Representative Geiger, go ahead.
Just noting that in the governor's supplemental budget is about $41 million going into a rainy day fund. And I guess my position is it's raining and it's a shame to lose this kind of money for investment in new companies in Maine when we so desperately need it. Thanks.
Are there other questions or other comments? Senator Lucchini.
Thank you, Mr. Chair. And I think just to echo the previous sentiments, I think this is one of the last places I'd like to see cuts. I really like the work of Maine Venture Fund, so I'll be voting against the motion to support this curtailment. And it's nothing against Mr. Norbert and the great work that he's doing. I have a ton of respect for him, but this one is an account that I feel is really important.
Are there any other comments? Seeing none, I'll ask Ms. Breton to call the roll. Ms. Breton, your mic. There you go.
Representative Geiger?
No.
Representative Geiger, no. Representative Andrews?
Yes.
Representative Andrews, yes. Representative Pebworth?
No.
Excuse me, I didn't catch that.
Yeah.
No, okay. Representative Pebworth, no. Representative Collmore?
No.
No. Representative Collmore, no. Senator Lucchini?
No.
Senator Lucchini, no. Senator COA, absent. Representative Ducharme?
Yes.
Representative Ducharme, yes. Representative Austin?
No.
Representative Austin, no. Representative Hassenfuss?
Yes.
Yeah, Representative Hassenfuss, yes. Representative Bailey?
No. No.
Representative Bailey, no. Representative Bernard?
No.
Representative Bernard, no. Representative Roberts?
No.
Representative Roberts, no. Senator Curry?
No.
Senator Curry, no. So it's 3 yeas, 9 noes, 1 absent.
Excellent. Mr. Shenoff, the next step in these recommendations are you are going to write a letter and communicate that to these votes with to the Appropriations Committee. Is that correct?
Yes, Senator. And the committee also has the opportunity, if there's other things that were not necessarily included in the supplemental that they would like to comment on related to the supplemental budget process to the committee, those thoughts can also be communicated in this letter if there's anything else the committee would like to convey to AFA.
Senator Lucchini.
Thank you, Mr. Chairman. And perhaps for Sam, I guess in reference to that last item 220, I don't know if we need to specify that a no vote would be just a full funding rather than the 50,000 curtailment just to fund in full. I don't know if that's worth putting in the letter or whatever. Thanks.
Representative Collmore.
Hi, thank you. I just would like to make sure that that we put in this recommendation, at least for me, in voting no on both the innovation and fame ones, that these are places we shouldn't be cutting money, given that we're in a state, especially for our small businesses, of bleeding. And I don't think that it's right to pull more from those bleeding businesses or stopping investment in ones that may come forward when we're trying to regrow, especially coming up to the summer, which is our biggest tourist season, and brings in the most revenue. Let's keep our businesses good. And I, again, don't want to offend anybody who's put a lot of hard work into doing these curtailments. This is just something that I feel very strongly about.
I can include language that the no votes reflect that sentiment in the letter.
And no offense taken, that's the best part about this process, is that we get to talk about it and you get to ask questions and debate it. And it's my favorite part of the job.
Having considered everything, I see no other comments, no other questions. I'll entertain a motion to adjourn.
So moved.
Or second?
Second.
What? I think in all in favor, we can raise hands on this one. Congratulations. We succeeded in our first public hearing, and I think this is our second work session. So congrats, everybody.
Great. I'll see you all next week. More public hearings.
Jody, if you could go ahead and turn off the live stream.